Good morning. Good afternoon, good evening to everyone. Sorry, we are just experiencing a bit of an echo here. We're trying to get that right. Thanks everyone for joining. We did experience where we appreciate everyone's patience and that we're starting a few minutes late. We had a bit of trouble with the link. So we have resent it. And please feel free to share it with colleagues if you think that some folks who plan to be on are not. And we'll move slowly so folks can catch up as they join on the link. But welcome to everyone. My name is Kate Konopka. I am the Global Health Advocacy Incubator Legal Director, and I am so happy to be sharing the virtual stage with so many of my teammates today to launch the Legal Advocacy Action Guide. This guide demonstrates how legal strategies are essential to advance and protect public health policies and to hold health-harming industries accountable. I'm going to do a quick overview of the guide and its process, and then I'm going to be turning the stage over to my teammates in order to go through the various chapters of the guide. Next slide, please. First, let me share with everybody that we do have interpretation available today. We have English, French, and Indonesian available for everyone if you prefer to listen in a different language. I do want to note that the Indonesian language is listed as German in the interpretation buttons. So we apologize for that, but please click on that if Indonesian is your preferred language, and you will be able to hear the presentation in that language. First up on this slide is a list of all of our speakers. These are team members who have contributed to the legal guide, and they're going to be speaking today about the various chapters. So I welcome each one of those in turn to the stage. Next slide. It took many more people than the folks that you just saw the pictures of in order to make this guide a reality. So we wanted to specifically list and really show gratitude to folks and to the full team who participated in this effort. So you see that list before you. These folks are largely lawyers from GHAI who contributed to the team, but there's also a significant participation from non-lawyers that participated in this and helped us get this guide into space and reality, and it is currently on our website. So we're very grateful to each and every one of these folks. Next slide. So a little bit of an agenda for our presentation today, and this agenda also tracks the legal guide, which is available for all of you to review on the website. So I'm going to do a quick purpose and overview of the legal guide, and then we're going to go into the various chapters. And specifically, the guide is going to discuss how to analyze the legal landscape and perspective in a particular jurisdiction in order to identify the most feasible and effective legal strategies, how to draft robust laws and regulations, and how to deploy litigation strategies in order to protect public policy initiatives and to hold health-harming industries accountable. Finally, we're going to talk about the importance of continuing to assess your strategies and develop them. Next slide. So this does what I just talked to you about in terms of the fact that this guide is analyzing the legal and political context of a relevant jurisdiction. It's going to give us checklists about how to develop robust evidence-based laws and regulation and deploy litigation strategies. The way the guide is designed is that each one of these strategies is detailed and explicitly explained, but then we supply a handy checklist for you at the end of each chapter, so that you have a checklist of various considerations and points that should be accounted for when you're considering one of these strategies. I also want to note, this is the table of contents of the guide, so you can see how these checklists are set up. I also want to note that there are at least 15 case studies throughout the guide so that you can see how these strategies have been deployed in action and in real life. And I want to give a note of gratitude to each one of our partners who actually did the work of these experiences and enabled the ability for these case studies to be in the guide. I just want to go over two important points before I turn the stage over to one of my teammates. First of all, the guide was written in an accessible manner for both lawyers and non-lawyers. So while lawyers may be needed to execute the strategies, the steps and the way in which the guide is designed was present in order to present clear flags and signposts for advocates so that they know the questions to ask and when and how to consult and deploy legal professionals and strategies. We hope you find that to be the case, and we very much welcome your feedback on that point. The second point that I want to make is that the guide is not exhaustive. It is designed around the primary strategies that lawyers deploy and that make up the bulk of GHAI legal team's work. But GHAI and others have a wealth of resources that further detail and provide flesh and depth for the steps and considerations that we're going to talk about today. So I encourage each and every one of you to reach out to us if you move through one of these strategies, and we're happy to participate, help, and support you in any way possible. With that noted, I am going to turn the stage over now to Veronica Poyano, who is one of our senior legal advisors at GHAI, and she's going to walk you through the first chapter of the guide. Thanks very much.
Thank you so much, Kate. Welcome, everyone. Now we are going to present the first step of our guide, which is analyze. Please, the next slide. In the analyze, we are going to present different steps that are very important to assess what is possible and feasible and strategic in each country. And this chapter includes several steps to conduct a comprehensive legal landscape and a mapping of a stakeholder and other steps that at the end, it will make feasible to assess the most effective legal strategy to achieve the public health objective that you are working towards. Next slide, please. The legal analysis is kind of the baseline work for any legal strategies. First, because it helps to clarify what is feasible, what are the feasible options for policy change that are grounded on the public health objectives and the specific legal and political context of each country. It also enables robust legal drafting that draws from and it is consistent with a larger body of laws in the jurisdictions and that supports arguments and legal arguments that appeal to the key decision makers and stakeholders in each country. And finally, it lays the foundation for an effective litigation by increasing the chances of success through a deep understanding of the legal system and the actors. Next slide, please. Here we present the steps or the checklist of the guide that all these steps are deeply developed in the guide, and I will walk you through a different, different step of each and some basic concepts. The first step for a successful legal analysis is to conduct a legal review. And in the legal review, it is important to keep in mind that we should include a different array of laws and regulations and other legal instruments. It is very important to review the current laws of the country, but not only those that are specific for the health policy that you are working towards. For example, it could be taxes, or it could be form of package labeling, it could be marketing. It is very important to also include other laws like constitutional provisions, human rights treaties that are effective in your country, and also very important to map and understand the governance laws that govern how the bodies of decision-making processes work, and how issues like transparency and conflict of interest is regulated or not in each country. The other important bucket of laws to include in the legal review is procedural laws to understand how the decision maker process is. And this will help to define, for example, the legal strategy, whether you are opting for pushing for a regulation or for a law in the parliament, or if the legal strategy guides you to decide for a strategy of litigation. Those will depend on this. Also, international laws and standards, for example, all the body of international human laws that are mandatory in many countries, but also the standards that are considered soft law are important to map. And also all the trade-related treaties and international standards that may affect the understanding of the public health issue at your country. And finally, it's also important to include in the legal review a mapping of the judicial and administrative decision of each country, even of international or other countries' regulations, because this can have a huge influence in the final legal strategy and also on the impact of it. The second step for the successful analysis is to map key stakeholders. And for us, for the legal strategy, it is important to understand who are the decision makers, or if you are doing litigation, who are the members of the court that you will be litigating. And it is important to understand what type of arguments these persons feels more compelled to, what are the entry points, and also what are the best moments to reach out to these audiences. The other steps is to understand what are the legal gaps and barriers of the countries. It could be barriers on the regulation itself, but also on the implementation mechanisms. And it is very important to decide your legal strategy that you have very clear picture of where these gaps or barriers are. Also, it is important to examine the enforcement mechanisms, meaning to assess the policies, laws, and regulations that regulate how these bodies of laws are interpreted, are enforced, and are monitored, and also identify potential gaps within these bodies of regulations. The next suggestion is to analyze past reform efforts. It could be, for example, bills that were presented into Congress, policy proposals, and analyze where were the standards of these policies or bills, what happened with them, there were flaws in them, and what are the opportunities to make it better. And also it is important to kind of understand who were the supporter for these past reforms, and also who were the opposing actors, because those those actors can also be relevant for your current legal work. And also in the same terms, it is important to understand the opposition tactics and also the opposition actors. Usually is the industry, what they are doing, and also what are the arguments that they are using. This industry sometimes uses arguments, constitutional arguments based on free trade provisions in constitutions that is better relevant to map and to be able to answer based on your legal framework. With all of these elements, you can define your legal strategy and move forward with the actions. And the final steps is the idea of this is a process that needs a continuous monitoring, because the legal landscape and also the political landscapes change a lot over time, and these changes can affect your strategy and the effectiveness of them. So, for example, if there are new regulations or a new decision by a court that could be make force you to make changes on your strategy. That's why it's very important to have this as a constant monitoring process. Next slide, please. And finally, as Kate was mentioning, our guide is illustrated by comprehensive case studies. And for this chapter, we included an amazing case study that illustrates how the analyzed steps can help to identify those legal opportunities to strengthen the regulatory framework of countries. In this case, it's the case of our partner from Colombia, GHAI, who challenged an amendment to a law that had weakened a conflict of interest rule for for members of Congress in Colombia and allow them to vote on legislation that could benefit the entities that had funded their campaigns. The Constitutional Court of Colombia declared this law as unconstitutional and ruled that they violated several democratic principles that were established on the Constitution. And within this case, it's very important because it shows how GHAI identified a serious risk on this law that seems at the beginning unrelated to food policy, which is the focus of our partnership with GHAI, but that ultimately kind of shaped the entire policy-making process. And another point of interest for the case is that GHAI used access to information requests kind of to build the evidence of how some policymakers had voted and make their case more stronger before the court. And the implication for this case were huge because it showed how conflict of interest can affect the advocacy strategy, the legal strategy, and the results were amazing because not only created better condition for advancing all the food and nutrition policy agenda and legal strategy, but also strengthened the democracy, and it got better for other public interest agendas by limiting the influence of big corporations in the food policy making process. And with that, I stop and I will hand it over to my colleague Mikateco, who will walk us through the next step on a legal guide.
Thank you so much, Vero. Hi, everybody. So we're now going to look at the second chapter, which is drafting. Next slide, please. Okay. So what is legal drafting? Well, legal drafting is the process of writing clear, enforceable, and constitutionally sound laws and regulations. It translates your public health objective into strong legal texts that can withstand legal challenges, trade dispute, and industry interference. If your analysis demonstrates the need and the feasibility of policy change through a new law, amendment, or regulation, lawyers should take the necessary steps to ensure that the drafting process is technically sound, aligned with best practices, and designed to meet the policy objectives. Next slide, please. So, why is legal drafting so important? Well, strong legal drafting transforms public health goals into enforceable, lasting protections. And it plays a key role because it protects public health laws from legal and political threats by anticipating challenges such as constitutional scrutiny, trade dispute, and enforcement gaps. It draws from global and local lessons to craft legally sound language that aligns with best practices while pushing for stronger protections where possible. It strengthens implementation and long-term public health impact by embedding clear procedures, accountability mechanisms, and adaptability to evolving evidence. It supports regulatory stability by grounding laws in scientific evidence and legal standards that endure across political cycles. Next slide, please. So, what are the steps that need to be followed for successful drafting? Well, effective drafting of public health laws and regulations requires drafters to translate the insight gained from the legal review and stakeholder mapping, as Vera has taken us through, in order for us to have a robust legal instrument. This includes choosing the best type of legal instrument. Will it be a law/legislation or regulation? It includes drawing from lessons learned from existing models and best practices. Have a look at other jurisdictions with similar legal systems and socioeconomic conditions. Look into what legal challenges they faced and consider that. It involves justifying and grounding policy with evidence. I cannot stress this enough. Evidence, evidence, evidence. Be it peer-reviewed studies free from conflict of interest, economic analysis, statistical data. You need to ground your work in evidence. So this will justify the policy that you're asking for. The use of effective language. We need to cut out the legalese. And as Kate mentioned earlier on, even with this guide, we try to make it as accessible as it can for non-lawyers. We are in our plain legal language era. You also need to determine the scope of application. Have your definitions within the legal instruments to aid in the interpretation of the legal instrument. Engaging and collaborating with different stakeholders is important. Collaborate with diverse stakeholders. Ensure that the voices of the marginalized are also echoed in the laws and regulations. This is very important to make your laws and regulations robust. You also need to include robust implementation and enforcement mechanisms. There has to be provisions on who will be the implementing body or authority or agency. What will be the monitoring and review mechanisms that will be in place? There has to be provisions on sanctions and penalties within the chosen legal instrument. Then we have to assess and minimize risk. You will have to evaluate the proposed law's susceptibility to legal challenges. You have to ensure the drafting is consistent with the country's constitution, other bodies of laws, and international obligations. You also need to ensure that the correct legal steps and procedural steps were taken in the passing of this particular law. Robust legal drafting is critical in defense of legal interference when doing our policy work and other opposition that may come across, including constitutional challenges, trade dispute, and shift in political will. Poorly drafted laws risk being overturned, misinterpreted, repealed, or rendered ineffective due to enforcement loopholes. We now have a case study, so I will then hand over to my colleague GHAI to take us through the case study that showcases the importance of sound drafting. GHAI?
Thank you, Mika, very much. And well, this case study from Puebla in Mexico highlights the importance of how strong legal drafting can protect laws from constitutional challenges, as Mika has just highlighted. So Mexico established the right to safe mobility in its constitution in 2020, and then adopted a general law on mobility and road safety in 2022, which set the national standard for protecting vulnerable road users, preventing traffic injuries, and also improving road infrastructure. In 2023, Puebla, that is a state in Mexico, approved its mobility and road safety law to harmonize with the national standard. The Human Rights Commission in Puebla challenged the law before the Supreme Court in Mexico and claimed that the mandatory insurance and certain penalties that were imposed for driving under the influence of alcohol were unconstitutional. We collaborated on an amicus brief submission together with Centrico, a leading organization in Mexico that works in road safety for many, many years, that presented the brief together with multiple organizations that work in road safety in Mexico and in Puebla. The amicus brief emphasized the robustness of the mobility and road safety law, and also its proportional measures to protect the right to safe mobility. The brief also demonstrated how the mobility and road safety law is consistent with the Mexican Constitution, the general law on mobility and road safety rights that was approved, and also international best practices to protect the right to mobility, life, and public health. All this to show that having a very, very well-drafted law can help when defending it against any challenge that could come. We're still waiting for the Supreme Court in Mexico to decide on the case, hoping it defends Puebla's law. And with that, I will turn it to Luján, who will guide us now through the litigation section of the guide. Thank you, Luján.
Great. Thank you so much, Jane, and thanks everyone for joining us today. So now I'll go through the third chapter of the guide, which is about strategic litigation. Next slide, please. Great. So in the guide, we did a very deliberate effort to try to define what strategic litigation is, and we have defined it as the deliberate application of legal processes to advance objectives that are beyond the particular dispute among the parties of the case. So this means that strategic litigation is not just about winning a case, but about using the power of the courts to drive systemic change. So even in cases where the public health objectives may not be realized by the tribunal's decision, our objective may not be achieved, litigation can always raise visibility, spark societal debate, and also generate pressure on policymakers to act. So our guide offers a roadmap to think through litigation not only as a legal tool, but also as a catalyst for advocacy strategies. Next slide, please. So why litigation strategies are important? As all of you in this call may know, as we are all advocates working in different spheres, even in the legal sphere, on research, on comms, we know that always public health policies face industry pushback, government inaction, or legal challenges that threaten either their adoption or implementation, but also their impact. So strategic litigation becomes essential in this context, but not only as legal remedies, but also as a way to protect and advance the public health objectives that we have achieved or want to achieve. So the guide offers guidance on litigation, both on affirmative and also defensive forms of litigation. We know that affirmative litigation is always initiated usually by advocates or organizations to compel action or accountability, while defensive litigation is used to protect policies and also civil society organizations from legal attacks. So both are crucial and often work hand in hand. So both of these types of litigations can offer these are like the list, the 4 little boxes that you see on the slides are just, are not exhaustive. So we know that litigation can do a few more things, but we wanted to highlight these 4. So litigation is essential, first of all, because it can defend policy wins, helping protect existing laws and regulations from being weakened, delayed, or struck down. And also litigation ensures that once a public health win is achieved, it stays in place and is properly enforced. Then it can also compel governments to meet their obligations. Litigation sometimes can force authorities to regulate, enforce existing laws, adopt new ones, or implement health measures grounded in constitutional or human rights obligations. Then litigation is a key tool to defend civil society organizations and advocates, since we have seen that many actors in the ground are being attacked due to the important work we do, facing lawsuits, censorship, or regulatory backlash. So litigation plays a critical defensive role to protect them and ensure that civil society and the civic space remains a powerful voice for accountability. And last but not least, we know that litigation is a key tool to hold health harming industries accountable. We know that for decades, many of these industries have pass the cost of their products and of their productions from health harms to environmental degradation to the public. So litigation can always expose these deceptive practices, uncover hidden influence in policymaking, and seek damages for their harm. So we need to send a clear message with litigation that is like public health comes before profit. So in the next slide, you will see that there are 8 steps that we have identified to go through a process that takes us to successful litigation. So we know that strategic litigation is not about just going to court. It requires, meticulous planning, legal expertise, and advocacy alignment. So these key steps can help build a strong and impactful litigation. So I'm going to quickly go through them because there are 8, but you can always navigate the guide with all the details of each of these steps. So the first one is, of course, choosing the claims and anticipating the challenges that we may have throughout this process. So we need to identify the right claims to bring based on constitutional, statutory, or procedural grounds available in a specific jurisdiction. Of course, that in this step, legal teams need to analyze which causes of actions are viable, what kind of proof is required, and how receptive courts have been have been to similar arguments in the past, or if this is a total like an innovative case that we need to bring. It's also essential to anticipate counter arguments early to reboot them strategically and be ready to do so, as we know that sometimes processes moves really fast. So the second one, and Mika made a lot of emphasis about the evidence that we need sometimes not only for legal drafting, but also for litigation. And we need that our claims are as strong as the evidence behind them. We need the evidence, of course, that will depend on our legal arguments, but this may include scientific evidence, economic analysis, for instance, of the public health costs, evidence of non-compliance or weak performance, and also comparative examples from other countries that may be useful for this case. Third, we need to also select the right plaintiffs and defendants. This, of course, it will depend if we're talking about affirmative or defensive litigation, as I talked before. But plaintiffs always need, legal standing, depending on the jurisdiction, and also like defendants must be selected strategically based on the legal grounds that will be used. And this, like the parties of the case, will always shape both the legal narrative, but also the public narrative of the case that may be used, for instance, in communication and media advocacy. So the fourth step is that we need to choose the appropriate forum according to what we are claiming. So not all the courts or venues are the same. Sometimes we need to consider whether we need to file a case in a national court, in a constitutional court, or in an administrative tribunal, depending on the nature of our claim and, of course, the remedies that we are seeking and the remedies that are available in a particular jurisdiction. So to do this, understanding procedural rules and past decisions from those forums is key. So then the fifth step that we identified is choose the right timing. And we know that strategic litigation is often and most of the times opportunistic. So filing at the right time during a policy window, or when public attention is high, or when public attention is also low, can increase the chances of success and amplify political impact, which is usually what we want with legal cases. And as we do this, and turning into the sixth step, we need to always evaluate and anticipate risks. So litigation is a powerful tool, but it's also risky. So assessing all the risks of a particular legal actions is key. And this is related to, I saw a question in the Q&A about, for instance, financial costs. So we need to consider that financial costs, like which resources we need, like legal setbacks, potential political retaliation or reputational attacks are all possible. So we need to consider that as we are designing a litigation strategy. And then the seventh step, which is also connected to the risk, is that we need to build coalitions and try to act as a group and mobilize support when we're thinking about litigation, because no legal action should stand alone. We need coalitions of civil society organizations, lawyers, academics, and health experts to bring credibility, visibility, and also technical strength before the court. And last but not least, of course, that we need to develop media strategies and communications strategies. That is a core component of strategic litigation, because communications help us amplify our cases, build public understanding, and also increase pressure on decision makers. So this is, there is much more information on the guide about the steps, but I'll now turn it to my colleague Ranjit, who will share with you 2 of the case studies that are included in the litigation chapter in the guide. Thanks.
Thank you, Louis. So, yes, I think she's explained the strategic litigation steps quite carefully. And these 2 cases will explain how some of the steps have been used. So there are 2 cases from 2 different countries, Kenya and India. So this is a Kenya case, which is basically challenge the public process of policy making, where the farmer's right to decide on the seeds were taken away by new rules which enabled GMOs at the cost of traditional seeds. What was startling was that there was no public, consultation, or the lack of drafting was not transparent. So, considering these aspects, the lawyers group challenged the reforms on the 2 grounds. Firstly, on the constitutional grounds, that this was, this was culturally not supporting the traditional seeds, and in fact supporting the GMOs, and the fact that there was lack of procedure in this. So in this case, the strategic litigation was a key tool to challenge the lack of transparency. The case is still pending, and there but we have used it very sustained way. This case has been used in Kenya. Next. This is closer to home. This is a case from India, where again, there was a complaint, a detailed complaint filed against the sugary drinks company. The drink was Bonvita. The case was framed entirely on the claims that they were making on the packet, claims like, health, uh, uh, strength to the, boosting immunity, more strength, etc. So these claims were very unsubstantiated. Also, they somewhere undermined the sugary content of that drink. So a complaint was filed before the Consumer Authority with the prayers to remove the deceptive labels and impose a penalty, as well as ensure that such kind of marketing, which are, because these products were essentially meant for children, are not there. This litigation was also supported by what Louis was showing in steps to litigation, point 7 and 8, because there was a coalition was formed between the parliamentarians, researchers, etc., that supported similar claims. And not only that, there was a series of complaints filed against different products, against against the health drinks, against the chips, against the biscuit manufacturers, all explaining the misleading labels on that. This was followed by a coalition of support from parliamentarians, as well as a huge media and communication advocacy. So this case basically advocated and expressed deceptive food label, and somewhere advocated the point of having a stronger labels. Following this case, there were a series of steps that have been taken by the Indian government by ensuring that the nutritional information, especially on fat, salt, sugar, appears in bold. There was a notification to e-commerce site not to have these drinks marked as health drinks. So there were a lot of steps that have been taken on these. So these were two examples that we use for in Kenya and India on how strategic litigation was used. Now I'll pass on for the next chapter to my colleague Janella.
Thank you, Ranjit and team. So we have arrived to the final section of the legal guide, which is assess. And so if we can go to the next slide, we have seen up to now that the legal guide helps advocates to chart a course for effective legal interventions to advance public health by analyzing the legal and the political context to develop the most feasible and effective objective and to deploy the legal strategies of legal drafting and strategic litigation. However, it is very important to note that effective legal advocacy is not linear in nature. The legal strategies are not one and done, but rather build on one another, and as well as complementary strategies that are very important, such as communications, to obtain the maximum public health impacts. So why ongoing legal assessment is important? So because, again, we must constantly assess and reassess our analysis and our choice of actions to continue public health progress and avoid backsliding. So what seemed most feasible and effective before, maybe less so now, or as milestones are met, we need to consider how to reach the next one. So we need to ensure that legal strategies remain effective and feasible by adapting to the changes in the legal political context. We also need to support a continuous cycle of action and adaptation, recognizing that legal advocacy is not linear, as we were saying before. And finally, we must strengthen the overall impact of our strategy by aligning the legal tactics with other complementary strategies, such as coalition building. And so we have our last case study we are showcasing in this webinar in the next slide. And just to say that you will see in the guide that we have 15 case studies from different countries around the world. So we invite you to read all of them. As in this turn, we are highlighting a case from Argentina. So as we were saying, effective legal advocacy doesn't stop with passing a law or winning in a court. It requires ongoing monitoring, defense, and adaptation. And in this case, the evolution of Argentina's healthy food law is a very strong example of how this plays out in practice. And this case highlights how partners in Argentina, namely FIC Argentina, FUNDEPS, SANAR, and FAGRAN, and I've seen that there are some participants in the call. They have played a key role in defending the wins and adapting to constant changes. So let's see what happened. Under President Macri, who was elected back in 2015, reforms moved very slowly, but there was a key groundwork that was laid. And the momentum picked up under President Fernandez, leading to a strong food labeling law in 2021, very comprehensive, with lots of support from civil society organizations, and thanks to an open progress and civil society support. Unfortunately, this support and this progress, was rolled back under President Milei, who has a regulatory agenda and sidelined health authorities and also civil society participation. There have been, in late 2024, new regulations were adopted that weakened the protections that were achieved, prompting legal challenges from advocates. So advocates got tired because they couldn't participate. They would request access to information and they wouldn't receive it. And so they said, okay, we need to litigate. And so these cases are still ongoing. There's a litigation that was initiated by FIC Argentina and FAGRAN against these changes in the regulation. And the cases are still ongoing, and we hope to have good news. But this highlights the critical role of the sustained legal action to defend the public health gains. We cannot stop once we have the public health gain. We need to continue in defending it and doing every activity that we can to defend these wins. So with that, I will handle it back to Kate and Juan, who will chair the Q&A section. Thank you very much.
Thanks, everybody. As you can see, we have a very deep legal team here at GHAI, and we wanted to make sure that we showcased that. So I really thank all of the participants and all of the panelists for walking us through these chapters of the legal guide. We now have about 10 minutes. So I do want to open up the floor for folks to ask questions. I believe you can put them in the Q&A, and Christy will be monitoring those so that you can put those in there and we can answer those for you. I also will, once questions come in, I will open up the floor to the other panelists to chime in as well. While we're waiting for some questions to come through, there is one question in the Q&A that Luhi highlighted in her presentation about the need for financial support in litigation. I do just want to highlight, in addition to a couple of things that Luhi said, I think it's very important to think about coalition building as part of a litigation process so that the litigation is not managed, and both in terms of the financial, but also in terms of the human capacity that litigation takes. So there's a real benefit to coalition building and thinking about partnering in terms of litigation. I also want to highlight, and I'll specifically harken back to Ranjit's case study in India, that not all litigation is expensive. So in a lot of cases, we can think about particularly administrative complaints that can be brought by an individual. In Ranjit's case, there was literally a consumer protection portal where those complaints could be registered online by an individual with little to no cost. And so there are a number of litigation strategies in different avenues and tribunals that can be accessed without a great either financial or human capital cost in terms of those aspects. Juan, I don't know if you want to have any reflections on the presentation and panel. I'll open the floor for you while we wait for questions.
Thank you, Kate, and thanks everyone for joining. We see many familiar names in the audience and the participants, many actual experts on these issues and on some of these cases. The one thing that I wanted to highlight that I think was present also in the comments of all the speakers today, but I just wanted to highlight it, is that litigation is another opportunity to do advocacy, another element to the advocacy strategy. And I think this was said by many, or the legal work in general is part of that. So, and I think Luhi, for instance, was highlighting that, but I think how these changes and takes into account the many other pieces of the advocacy work, how this is connected to decision makers, to the specific context, and how that changes the way in which the legal work, lawyers, and potential litigation interacts with those elements is very important. And it's very important to be aware of those elements that are very dynamic, to be able to change in the process, to be flexible and adapt. And I think also GHAI talked a little bit about that in her comment. I think now we have a few other questions.
Yes. Thanks, Juan. So the first question is an important one, and it speaks to the first chapter of the guide in terms of the analysis and legal review. And it asks whether the guide has examples on which types of legal instrument might be more useful depending on the context, and how can one assess if it's more probable to pass a decree or a law. So the guide actually does include a chart in terms of whether the various aspects of a law versus the various aspects of a regulation. So it guides through the idea of which might be a better instrument at different times than others. I will caution that that is very dependent on the context. And so to give you a couple of examples, when we think of a law, we usually think of something that goes through the legislative branch of government. And when we think of a regulation, we usually think of something that goes through the executive agency or an executive branch of government. A lot of the calculus in terms of which of those may be better in a current context and jurisdiction may be where your champions lie. So that may be something that's not intuitive from a legal perspective, but in terms of the mapping the stakeholders part of the analysis, you may determine that you have more friends in the legislative branch than in the executive branch, and you want to think about going that route in order to have more champions. A couple of other factors to think about are that a law tends to be much broader based and give parameters for something, while a regulation may be more specific and detailed. So we take you through these various aspects in the guide. We hope that you will find that part of the guide very useful, but if you have more questions, specifically about your context, we definitely ask you to reach out to us, and we're happy to brainstorm and talk about that with you. Juan, I want to open up the floor to you as well if you want to pick a question, or if you have any reflections on the ones that are
Thank you, Kate.
on
Yes.
the Q&A board.
Thank you. Emmanuel from Nigeria talks about the importance of the Freedom of Information Act to the broader advocacy work, and including for potential cases. And I just want to highlight that comment. I think that's a very, very important answer or comment. Within the guide, we try to highlight the different ways in which the legal work can be used to advance advocacy efforts. And I think using Freedom of Information Acts or similar laws and regulations in different countries is certainly a key way to do that. There's another question, whether it's important to connect with legal brain from outside a specific country for litigation. I think that's kind of what we try to do, both from GHAI, but also connecting the experiences from litigations in different cases. So when we see similar patterns, we try to share what other partners have done in other parts of the world. Of course, that needs to be adapted to specific countries, but we do try to do that, and we hope that that's helpful. We always know that the local lawyers are the one who actually know the specific legal system, and they're, of course, leading the cases, but we try to be helpful in that, and also not only within the GHAI team, but also, as I said, identifying similar cases in the world. And yeah, there are growing cases, both in food policies, but in other areas of public health that I think we can rely on. Some courts are more easy to influence with foreign cases than others, but I think that's, at least it's useful to have that in mind.
Thanks, Juan. I love the question about the importing legal brains. I just like the way it was phrased. But of course, that is exactly what we try to do. We try to facilitate those communications among our various partners in different countries in order to make sure that the legal expertise is not kept in one jurisdiction, but we're actually proliferating that across the globe. And we've had a number of examples of collaboration where just recently a partner from Colombia helped a partner from South Africa in terms of drafting an opinion in support of one of their cases. And we try to facilitate those types of connections as much as we can. So if you feel in need of one of those, please reach out because we're happy to help with that. And I think Juan was answering this question as well in terms of the leveraging case studies or jurisprudence for other jurisdictions. Certainly, I think it's absolutely correct, as Juan mentioned, that some jurisdictions find foreign jurisprudence more persuasive than others. But certainly, if you don't have authority in your own jurisdiction, courts will often look outside the jurisdiction as to what others have said. And we should also think about not only other national jurisprudence, but international statements and comments that may be of use. There is a question from how long does the advocacy take to reach the desired goal? That's kind of the $1 million question in almost all of our cases. Sometimes things move very quickly, and sometimes 7 years later, we're still thinking about how to make progress. But it's absolutely correct that there are ebbs and flows. And one thing to be very important, one thing that's very important, and the guide marks this significantly, is that it's very important to not just think about the final result, but also to think about the milestones that come along the way. And as part of those milestones, to reassess your strategy. So as you're moving forward, there may be some incremental amount of progress. And we want to then take that moment to take a breath and re-look at our strategy and think about whether we should be staying the course or whether we should be changing or pivoting in some way to make sure that we continue the progress. Juan, I'll turn it over to you. There's a couple of more questions below.
Yes, I think we're reaching the time. I just want to highlight Matt's question. Thank you, Matt, for joining the webinar. It's an honor to have you. And I think on how to share this resource with advocates around the world, we are hoping to rely also on the many networks in which we participate and also on the many participants to this webinar. We're hoping to use those legal networks, but also advocates networks in general to spread the word about the guide. And hopefully that actually happens. But thank you. And thanks everyone for joining us today.
Thanks, Juan. We are at time, but I just want to quickly address a couple of last points in the chat. Obviously, if folks need to drop off, we understand. But there was a question about what was the most difficult part of writing the legal guide, and what were the challenges that you faced to identify the steps. I think the most difficult and also the best part of this guide was how many participants there were in the writing of it. So I think, we were able to draw from a very deep bench of experience, both on the legal side, but also in the non-legal side in terms of folks who are brilliant writers, advocates, strategists, and the ability to consolidate that input into a cohesive document that was not 140 pages long, so none of you would read it, was a real challenge. I hope that we met it for you, but we really are looking for your feedback. So we would love for folks to review the guide and reach out to us offline. to give us your feedback and perspective on how it's working for you, particularly as you work through some of these strategies. And then just as a last point, I think this was more of a comment than a question, but someone indicated that efforts must be made to insulate public policy, particularly those related from political challenges. That's absolutely the case. It's also very important to protect our civil society organizations from attack, which we are seeing more and more. And the guide specifically addresses the points of both protecting public policy, protecting civil society organizations, and holding health harming industries accountable. I invite you to read those sections, and please reach out to us if you have any further questions. With that, I don't want to hold you more than 2 minutes past time. So thank you very much for participating today. We really appreciate it, and we really look forward to your views and feedback on the guide. Thanks very much.